We are back with some breaking news. Judges in the Eastern District of Virginia are moving to select a new U.S. attorney after Lindsay Halligan was found to be unlawfully appointed to her role in December. As a reminder, Halligan secured indictments against New York Attorney General Letitia James and former FBI Director James Comey, but those charges were tossed. Let's bring in MS Now Justice and intelligence reporter Ken Delanian. Ken, what are we learning?
What happened inside the Department of Justice did not begin with a dramatic announcement. There was no single moment where everything suddenly changed. Instead, it unfolded quietly, step by step, through decisions that, on the surface, appeared procedural, but together created something far more serious. At the center of it all was a federal office with enormous power, the United States Attorney's Office for the Eastern District of Virginia. This is not an ordinary jurisdiction. It handles some of the most sensitive cases in the country: national security matters, cybercrime, intelligence-related prosecutions, and high-level corruption cases. The person leading that office holds influence over decisions that can shape national policy and public trust. Into that position stepped Lindsay Halligan. She was not a career prosecutor. She had not built her reputation inside the Department of Justice. She had never stood in a federal courtroom representing the United States government in a prosecution. Her background was in private legal practice, and more significantly, she had previously served as a personal attorney to Donald Trump. That alone raised eyebrows. But what followed raised far more serious questions. Her appointment did not go through the traditional process. Under normal circumstances, a U.S. attorney is nominated by the president and confirmed by the Senate. This process exists to ensure oversight, to test qualifications, and to prevent exactly the kind of concentration of power that could lead to abuse. Instead, a temporary appointment mechanism was used, one that allows a president to install an interim official without Senate confirmation for a limited period of time. That mechanism comes with restrictions. It is not meant to bypass scrutiny entirely, and it is not designed to place unqualified individuals into powerful positions indefinitely. Almost immediately, legal experts began to question whether Halligan even met the requirements for that temporary role. Then the courts got involved. Federal judges in Virginia began examining the legality of her appointment. At least one judge concluded that she had not been lawfully installed in the position. That should have been the end of it. In most situations, such a ruling would force a correction, either a new appointment or a halt to her authority. But that didn't happen. The Department of Justice continued to treat her as the acting U.S. attorney. Official documents still carried her name. Decisions continued to be made under her authority. And as this legal disagreement played out, something else began happening inside the office. Changes. Not small adjustments, not routine restructuring, a pattern. Experienced prosecutors, people who had spent years, sometimes decades, building cases, working with federal agencies, and navigating complex legal standards began to disappear from their positions. These were not individuals accused of misconduct. They were not underperforming employees. Many of them had strong track records, having worked under multiple administrations from both political parties. Their issue was something else entirely. They pushed back. When certain cases were brought forward, cases involving high-profile political figures, they reviewed the evidence and raised concerns. They questioned whether the legal standards were being met. They asked whether the cases could withstand scrutiny in court. They expressed doubts that any seasoned prosecutor is trained to consider. In another time, that would have been seen as professionalism. Here, it became a problem. One by one, those who resisted found themselves removed from their roles. Some were dismissed outright. Others were forced out under pressure. The message, whether spoken or not, was clear enough to everyone watching. Agreement was expected. Resistance had consequences. And then came the cases themselves. Among the most striking developments were federal charges pursued against individuals who had long been public critics of Donald Trump. These included high-profile names, people who were not obscure figures but central players in past investigations and political conflicts. The decision to pursue those cases was controversial on its own, but what made it more significant was how it happened. After internal resistance from career prosecutors, Halligan reportedly took direct control. Instead of assigning the cases to experienced trial attorneys within the office, she moved forward herself, approving charges and signing indictments. That decision carried enormous weight. Because if her authority to serve as U.S. Attorney was invalid, then every action taken under that authority could also be invalid. That is where the situation moved from controversial to potentially explosive. Legal teams representing those charged began preparing arguments that went beyond the details of the cases themselves. They focused on the foundation, the legitimacy of the person bringing the charges. Their argument was straightforward. If Halligan was not lawfully appointed, then she did not have the power to initiate prosecutions, and if she did not have that power, then the indictments could not stand. It is a technical argument, but one with massive consequences, because it doesn't just affect one case, it affects everything. Every indictment signed, every legal decision made, every action taken under her authority. If a court agrees with that argument, entire cases could collapse, not because of innocence or guilt, but because the process itself was flawed from the beginning. And the ripple effects would extend far beyond the individuals involved. Other defendants in completely unrelated cases could challenge their prosecutions on the same grounds. Defense attorneys would argue that the office itself was not properly authorized. Appeals could flood the system. Convictions could be questioned. Ongoing trials could be disrupted. What began as a single controversial appointment could turn into a systemic legal crisis. Inside the Department of Justice, the impact was already being felt. Reports described a workplace under strain. Confidence in leadership was shaken. Conversations that once centered on legal strategy began to shift toward uncertainty and risk. Prosecutors found themselves asking difficult questions. What happens if I refuse a case? What happens if I speak up? What happens if the rules are no longer clear? For many, those questions didn't have reassuring answers. Some began to leave, others considered it, and those who stayed faced a new reality, one where the boundaries between law, politics, and authority felt less defined than before. At the same time, the timing of these developments added another layer of complexity. The country was moving closer to a major election cycle. Political tensions were already high. Public trust in institutions was under pressure, and now the justice system itself was becoming part of the conversation. When high-profile political figures are charged with crimes, it doesn't happen in isolation. It shapes narratives. It influences public opinion. It becomes part of a broader political landscape. Whether intentional or not, the effect is powerful. An indictment, even one that is later dismissed, can alter reputations, shift attention, and create lasting impressions. That reality makes the integrity of the process even more important. Because once questions are raised about how those decisions are made, about whether they are driven by evidence or influenced by other factors, the impact goes beyond any single case. It reaches into the foundation of the system itself. That is where things stood. A contested appointment, a clash between courts and the Department of Justice, a series of high-profile cases, and a growing sense that something deeper was at stake. The courts now hold a critical role. They are being asked to decide not just on individual legal arguments, but on the boundaries of executive power, on the limits of temporary appointments, on whether established processes can be bypassed, and if so, to what extent. Their decisions will not be narrow, they will shape precedent. If they uphold the appointment, it could expand the authority of future administrations to install officials without traditional oversight. If they reject it, it could reinforce the constraints that have governed the system for generations. Either way, the consequences will be felt long after the current situation is resolved. Because at its core, this is not just about one person or one office. It is about how power is used, how laws are interpreted, and how institutions respond when those boundaries are tested. And as the legal battle continues, one question remains unresolved. What happens next depends on decisions that are no longer being made behind closed doors. The situation has moved beyond internal disagreements and into a full-scale legal and institutional test, one that now involves federal judges, constitutional interpretation, and the limits of executive authority. As challenges to Lindsay Halligan's appointment continue to move through the courts, the focus has shifted from speculation to consequence. If a federal court definitively rules that her appointment was unlawful, the impact will be immediate and far-reaching. The first and most obvious effect would be on the cases she personally approved. Any indictment signed under her authority could be challenged and potentially dismissed. That includes high-profile cases that have already drawn national attention. But the deeper issue is not just about those individual prosecutions, it's about legitimacy. In the legal system, authority matters just as much as evidence. A case is not only judged by what is presented, but also by who has the power to present it. If that authority is invalid, the entire process becomes unstable. That is exactly the argument defense teams are now preparing to make. They are not just contesting the facts of the cases, they are questioning whether the cases should exist at all. And if courts agree, the consequences won't stop with a few dismissed charges. They will spread. Other defendants, people with no connection to politics, could begin filing similar motions. They could argue that their cases were handled by an office that was not properly authorized. Appeals could multiply. Courts could become overwhelmed with procedural challenges. What initially appeared to be a narrow legal dispute could evolve into a broader disruption of the justice system in that district. That possibility is already being taken seriously by legal analysts, because this isn't just about correcting a mistake. It's about determining whether the structure of authority was compromised in a way that affects everything built on top of it. At the same time, the Department of Justice faces a difficult position. If it continues to defend the appointment, it risks further conflict with the judiciary. If it reverses course, it may have to acknowledge that key decisions were made under questionable authority. Neither option is simple. Internally, the pressure is building. Career officials, those who have spent years working within established norms, are now operating in an environment where those norms feel uncertain. The traditional understanding has always been that prosecutors act independently, guided by evidence and legal standards rather than political influence. But when leadership decisions become controversial, that independence can feel less secure. This creates a subtle but powerful shift. Instead of focusing only on legal merit, individuals begin to consider risk. Not just the risk of losing a case, but the risk of making the wrong decision in a changing environment. Over time, that kind of pressure can alter behavior. It doesn't require direct orders. It doesn't need explicit instructions. The possibility alone is enough. And that is what makes the current moment significant, because the long-term impact may not come from any single action, but from how the system adapts to uncertainty. At the political level, the situation is already influencing the broader conversation. With elections approaching, legal developments are no longer isolated from public perception. High-profile cases, especially those involving well-known political figures, quickly become part of campaign narratives. Supporters see accountability, critics see targeting, and the line between law and politics becomes harder to define. That dynamic is not new, but the intensity of it is. When trust in institutions is strong, legal actions are more likely to be accepted as legitimate, even when controversial. But when that trust is weakened, every decision is scrutinized through a different lens. Motives are questioned, intentions are debated, and outcomes are interpreted in multiple ways. That is the environment in which this situation is unfolding. Meanwhile, the courts are moving carefully. Judges are aware that their rulings will carry weight beyond the immediate case. They are not just deciding on technicalities, they are shaping how similar situations will be handled in the future. If they set a precedent that allows broad use of temporary appointments, future administrations may rely on that pathway more frequently. If they restrict it, they reinforce the importance of established procedures and oversight. Either direction has implications, because once a boundary is defined, it doesn't just apply once. It becomes part of the system. Congress, too, could become involved. Lawmakers have the authority to conduct oversight, request documents, and hold hearings. They can examine how decisions were made, whether existing laws were followed, and whether changes are needed to prevent similar situations in the future. But whether that happens and how effectively depends on political dynamics. Oversight is most powerful when there is agreement on its necessity. When that agreement is absent, action can be limited. So for now, much of the focus remains on the judiciary. As legal arguments continue, one central issue keeps returning. Where does executive power end, and where must institutional limits hold firm? That question is not new. It has been asked in different forms throughout history, but each time it appears, the context is different, and the answer shapes what comes next. In this case, the answer will influence how key legal positions are filled, how independent prosecutors can operate, and how much flexibility exists within the system. And beyond the legal details, there is a broader consideration: public confidence. The justice system relies not only on rules and procedures, but on belief that those rules are applied fairly, consistently, and without undue influence. When that belief is strong, the system functions more smoothly. When it weakens, even correct decisions can be questioned. That is why moments like this matter, not because they provide simple answers, but because they test whether the system can handle pressure without losing its core principles. For those watching from the outside, the details may seem complex: legal statutes, appointment rules, procedural arguments, but at its core, the issue is straightforward. Who has the authority to enforce the law? How is that authority granted? And what happens when those boundaries are challenged? The answers are still being written. They will emerge through court decisions, institutional responses, and public reaction. And once they do, they will not just resolve the current situation, they will define expectations for the future. Because systems are not only shaped by how they are designed, they are shaped by how they respond when tested. Right now, that test is underway, and the outcome will determine not just what happens next, but how similar moments are handled for years to come.